Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a petition for certiorari that has been filed in the United States Supreme Court. And it's interesting because the question that it raises is this: does the government have to follow its own rules? So let's talk about that. So Ms. Diaz, in this case, went down to Mexico to visit her family. And while she was down there, her boyfriend needed to go back north, so she let him borrow her car, and she took his car back across the border. On the way back across the border, they discovered methamphetamine. She was arrested, she was tried, convicted, and sentenced to 7 years in federal prison. This petition raises a defense that I believe should have been dispositive, and if she had been arrested in Texas, it would have been. But she was arrested in the Ninth Circuit, and as a result of that, it was held not to be a problem. So let's take a look at the petition, and then I'll have a little bit more about this. So when you ask the Supreme Court to take a case, you file what's called a petition for a writ of certiorari, and you do it to the United States Court of Appeals for the Ninth Circuit. You file the petition with the Supreme Court, but the writ goes to the Ninth Circuit. And the writ of certiorari means send the record up. Send the record up so that the Supreme Court can review it. So this is a case of Delilah Diaz versus the United States of America, and this is the question presented. Federal Rule of Evidence 704B provides, in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. Those matters are for the trier of fact alone. The question is, in a prosecution for drug trafficking, where an element of the offense is the defendant knew she was carrying illegal drugs, does Rule 704B permit a governmental expert witness to testify that most couriers know they are carrying drugs and that drug trafficking organizations do not entrust large quantities of drugs to unknowing transporters? Or, more simply put, is the government required to follow its own rules? The relevant statutory provision is from the Federal Rules of Evidence. It says, in general, an opinion is not objectionable just because it embraces an ultimate issue. So, for example, in a negligence case, an expert is allowed to opine that a doctor, for example, was negligent because he did not take a pulse or check a blood pressure. But in a criminal case, an expert can't do that. An expert must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. Those matters are for the trier of fact alone. So an essential element of proving importation of illegal drugs in violation of the Controlled Substances Act is the defendant knew she was transporting the drugs. This element is necessary to separate wrongful conduct from otherwise innocent conduct. She was apprehended at the southern border where investigators found methamphetamine hidden in the doors. For many years, the federal government has recognized that drug trafficking organizations in Mexico sometimes use blind mules, basically people who don't know they are transporting drugs across the border. Petitioner maintained that must have happened here. To rebut the petitioner's defense, the government called a Homeland Security agent to testify in an expert capacity that in most circumstances the driver knows they are hired to transport drugs and that a drug trafficking organization does not trust a large quantity of drugs to unknown drivers. Petitioner argued that this testimony violated Rule 704. The District Court and the Ninth Circuit disagreed, holding that the testimony implicates that rule only when it provides an explicit opinion on the defendant's state of mind, meaning otherwise that she knew or she didn't know. In the Fifth Circuit, the rule prohibits not just the explicit opinions, but also the functional equivalent of a prohibited opinion on mental state. as the Fifth Circuit has repeatedly applied this rule to preclude testimony identical to the agent's testimony here. The court should grant certiorari to resolve this split between the circuits because it's clear and entrenched, and it also impermissibly lightens the government's burden to prove knowledge beyond a reasonable doubt. In other words, or to put it differently, just because an expert offers an opinion that most of them know, most days are sunny, but that doesn't mean that it doesn't rain. So they have to prove this beyond a reasonable doubt, and I would agree, this definitely lightens the government's burden. So on August 17th, 2020, she was driving back home from Mexico to California, and the agent heard a crunch-like sound when she rolled down the window. Now, clearly, if she knew she had stuff in the car, she wouldn't have rolled down the window, particularly if she knew it was in the door panels. But inspectors found 27 kilos of meth, and as a result, they arrested her. She told them, look, I don't know the drugs were in the car. She said, look, I went down to visit my boyfriend, a guy by the name of Jesse, and Jesse let her drive his car home, telling her he would pick it up in a few days. So, the petitioner was charged with importation of methamphetamine, and she continued to insist that the element of knowledge was not satisfied, and at trial the government called Andrew Flood, a Homeland Security agent, as an expert on drug trafficking organizations. Based on his experience investigating other cases, which of its very nature is biased, Agent Flood testified that drugs are packaged in Mexico and hidden in cars and other vehicles to be transported from point A to point B across the border. In response to the prosecution's question about whether in his training and experience transporters are compensated, he said, yeah, it's a job. You take it from point A to point B. And he said they are usually paid with money or the use of the vehicle. The prosecution then asked Agent Flood, based on your training and experience, are large quantities of drugs entrusted to drivers that are unaware of those drugs? He responded, no, in extreme circumstances, actually in most circumstances, the driver knows they are hired. Now that's a tell right there. When you start off with extreme circumstances and then go to most circumstances, that's a pretty big difference. And generally speaking, when people make a slip like that, the original point was the truth. At any rate, he testified that it was a business, that they're not going to risk their market and that sort of thing. So, since they were hidden inside her boyfriend's car and that she was driving home from a one-off personal trip, it didn't fit with any of the prior experiences or situations or schemes that Agent Flood described. Nevertheless, the jury found her guilty and she was sentenced to 7 years in prison. Now, they drop a footnote here to keep everybody honest. That sentence was reduced from the mandatory minimum of 10, partly as a result of a proffer made in which she disclaimed her blind mule defense. And you're probably thinking, well, if she disclaimed it, why are we at the Supreme Court? Well, for one very good reason. The proffer plays no role in the appeal. The government bears the burden of proving guilt beyond a reasonable doubt at trial. Alleged errors regarding the admission of evidence during the guilt or innocence phase, therefore, cannot be deemed harmless based on new admissions made at sentencing, because people often say things to get 3 years cut off of their sentence. I'm pretty sure that even if I was innocent, if I'd been convicted, I would do just that. So, here are the reasons for granting the writ. The first is that there's an entrenched split on the question presented. In the Ninth Circuit, you have this ability to testify to the functional equivalent of knowledge. In the Fifth Circuit, it came about as a result of this Gutierrez-Farias case. They don't have that. The Fifth Circuit continues to enforce its holding that if it is, in essence, the functional equivalent of saying they knew, then you don't get to have the expert render that opinion. The Ninth Circuit holds that the rule permits the testimony because it's not an explicit opinion on the defendant's state of mind. No, it's a backdoor expert opinion that says she knew. In Murillo, for example, the court found that no Rule 704B violation where an expert agent described how drug traffickers do not entrust large quantities of drugs to people who are unaware that they are transporting them. So, obviously, that's how they go about lowering the burden of proof. The 8th and 11th Circuits have sided with the 9th. The 5th Circuit says, no, we're going to apply Rule 704B as it is written. So, there is a pressing need to resolve the conflict because the majority of people who are busted for transporting drugs across the southern border are arrested either in Texas, 5th Circuit, or in Arizona or California, which is in the 9th Circuit. So there is a split between these two circuits, and it needs to be resolved. So that's why they want the Supreme Court to come in here and wade in and solve this problem. The government prosecutes thousands of drug trafficking cases each year, and they're mostly in the 5th and 9th Circuits. And they draw those statistics from the U.S. Sentencing Commission's quarterly data reports. The government frequently seeks to elicit expert testimony about typical roles within drug trafficking organizations in order to prove that a defendant participated in a drug trafficking conspiracy. This modus operandi testimony usually does not implicate 704B, but it can cross the line, at least in the 5th Circuit, when the expert begins matching those roles to individuals in the case, including the defendant, and that's what they did here. And this case, according to the defendants, is an excellent vehicle to evaluate the reach of Rule 704B. And it presents a clean vehicle to say, no, you don't get to do this. Rule 704B means what it says. And whether it's explicit or implicit, it is still a comment on her state of mind. And if the Supreme Court is going to do anything in terms of evening the scales here, the best way to even the scales is to reverse this conviction and give this young lady her life back. Now, before I get to my comments, I just want to say that I have no idea whether this woman was actively involved in transporting drugs or not. That isn't the issue. The issue is, does the government have to apply Rule 704B in its proper context? In other words, if an expert came up for the defense and said, most people, when someone loaned them a car, don't think to go through it and look for drugs. If they were an expert in that area, then they should be allowed to testify to that fact. But again, it's a question of sort of fuzzy expert testimony. Because how does an agent know what drug trafficking organizations do other than through what he has seen? But even that doesn't tell him about the state of mind of the person who's entrusting those drugs to the driver. So I have a lot of problems with it just on the basis of foundation and the basis for the expert's testimony. And again, she might very well be guilty. This might have been her 19th trip running drugs, and this might have been the defense that they had planned all along. I don't know. But again, the issue is, does the rule apply? And that's what we're trying to figure out here. So petitions for certiorari are rarely granted. I think it's less than 5% are granted every year. And there are several ways that you can get a petition for certiorari granted. One is to have a legitimate constitutional question that has arisen through the state courts. For example, a lot of the abortion and gun rights cases have arisen through the state courts, like the Bruin case, and it dealt with a federal constitutional right, and the court took that case to resolve the issue. There is also a way called conflict in the circuits, which means that if the Ninth Circuit answers a question one way and the Fifth Circuit answers the same question, the other way, you have a conflict in the circuits and the law is in discord. And that means until that conflict is resolved, you're going to have people falling through the cracks. In this particular case, that's the reason, if at all, that this case gets granted. Ms. Diaz is not somebody who would normally engender a lot of sympathy from the right wing of the court because she's involved apparently with drug dealing. Well, she's convicted of drug dealing. Whether or not she was actually involved, I think, is another question. When you go through the case, you see that this was not her car. She didn't have any knowledge as to what was in that car, or at least that's what she claimed. Now, maybe she knows, maybe she did know, I don't know. But one of the things that we don't do in this country is we don't employ mind readers to try and convict people. And yet, in that particular case, that's what they did. There is a very clear rule under Rule 704 that says the expert can't opine on an individual's mental state. Well, if you opine that, well, this is the usual way, and I can't believe that a drug organization would trust this to a novice or somebody that, wasn't actually involved in the drug trade, then what you're essentially doing is you're basically telling the jury that they can ignore her protestation that she didn't know this was drugs because other people who do this for a living, who catch drug dealers for a living, believe that this is not the case. But that is not evidence. That is mere belief. And the fact that the court allowed expert testimony here in violation, I think in clear violation of Rule 704, should be a reason for the Supreme Court to take the case. Now, a true conservative, if they are really a true conservative and not just a political tool, believes in the plain language, that you enforce things on the basis of the plain language. And if you are prohibited by rule from giving an opinion on a person's mental state, and what you do instead is give your own opinion on what their mental state is by not describing it as their mental state, by saying, well, there's just no way she couldn't have known, that is essentially the same thing. And just because he didn't explicitly say, oh yeah, she knew, that does not relieve the issue in my book. We'll have to see whether the court takes this. I think that they should take it, but if they do, I will let you know. And if the Supreme Court does take this petition and does come out on the Fifth Circuit side of this ruling, reversing the conviction and letting that poor lady out of jail, Delilah, you need a new boyfriend. So that's what I have for you today. It's a little different than what I normally do, but I thought it was an important case and I wanted to bring it to your attention. Every day in this country, people walk by others in wheelchairs and never make eye contact with them. It's like when they're in that wheelchair, people do not see them. The feeling of not being seen is equivalent to the feeling of not mattering. If you see somebody in a wheelchair today, drop your eyes, make eye contact with them, and say, good morning, good afternoon, how you doing, nice to see you, something. Make contact. Reach out. I believe what you'll find is that it will make their day. And here's a funny thing about kind acts like that. If you do just one per day, you will find that you want to do more because you get good feedback from that. And it becomes a feedback loop, and you will find yourself doing other kind things. It's a marvelous feeling and a marvelous experience when you can make somebody else's day better. Just keep that in mind. Thanks for watching. Come catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.